It's a real honor to talk to you today with some of my favorite people in the world. My job is to give you kind of a thumbnail sketch of what this process is all about. I will tell you, though, offhand or up front, that I did not get into this with the idea of becoming an expert on Article 5. As a constitutional scholar, one of the things I do is I go through the Constitution looking for parts of the document that have been either not written much about or the stuff out there is not very good. And boy, was that ever true of Article 5. Not only wasn't there very much stuff written, but it actually wasn't very good. And so what I did is I became immersed in the history in the background. I used to believe, for example, that the convention called under Article 5 was a constitutional convention. I was wrong. I used to believe that there was a runaway danger. I was wrong. I simply learned, well, you know how they say, it isn't the things that you don't know, it's the things that you do know but that aren't true that are the problem. And that was my problem. All the things that I thought I knew about this process just weren't true. Now, let's start off with just a little bit of historical background so you can see where this thing came from. Today we tend to think of the Constitutional Convention as a one-of-a-kind, unique sort of event. Something like that never happened before or ever happened again. One of the surprises that I learned about was that that wasn't true. That in fact it was really common during the 17th and 18th century for colonies and states to meet together in conventions. Before our independence was declared, various colonies had met together in conventions about 20 times. And after independence was declared, there were 10 meetings of states before the Constitutional Convention. I also learned that many of the people at the Constitutional Convention themselves had an extensive history of convention going. And so that when they write into the Constitution the phrase convention for proposing amendments, they knew exactly what they were talking about. Hamilton, Madison, John Dickinson, Roger Sherman, etc., John Rutledge, virtually all the most influential delegates at the Constitutional Convention had had extensive experience with prior interstate conventions. They understood exactly what they were about. They also understood that there were certain common protocols that were followed at all these conventions. When I got into reading the articles about the subject, I realized that they didn't have a clue. I mean, they asked questions like, how do we choose the delegates? And how many delegates are there going to be from every state? And how are the delegates going to be apportioned? And yet the founding era record gives us all of that information because the protocols were worked out over a period of more than a century before the Constitutional Convention ever met. For example, we know that a federal convention is a meeting of the states. It was regularly referred to as a convention of the states. The Supreme Court has used the same term, convention of the states. It's not some mass body of representatives from the people generally like the House of Representatives. It is instead a meeting, a diplomatic meeting of representatives from the various state legislatures. These representatives are called commissioners, and each delegation sent from every state is called a committee. And each committee gets one vote. California's committee gets one vote, New York's committee gets one vote, Rhode Island's committee gets one vote, Wyoming's committee gets one vote, and so forth. The convention makes its own rules, it elects its own officers. We also know that this convention was designed by the framers as a way of getting around Congress in case Congress ever became abusive or oppressive, which of course we know could never happen. Mike Ferris referred to the memorable moment at the Constitutional Convention when George Mason, one of the greatest delegates, stood up and said, this government could become abusive and the people have got to find a way to rein it in. The founders saw this method as the primary way or a primary way in which the people acting through their state legislatures could check the federal government and bring it back to its constitutional limits and end oppressions. That was its purpose. That's why it was put in. The power that you as state legislators have to do this is not given to you by your reserved power of the states. You know, we think of the 10th Amendment, all powers not delegated or reserved to the states. The power that you have to save the country, because that's what the power is, the power that you have to save the country is given to you by the people of the United States through the Constitution. When you act to apply to Congress for a convention on a particular topic or topics, when you act to ratify amendments, when the convention acts, all those bodies act pursuant to enumerated powers granted them by the Constitution. It follows, of course, that you can't do anything contrary to the Constitution. And by the way, the authority for that proposition is not just the founding era. The authority for that proposition is a series of cases decided by the United States Supreme Court in the 20th century. Another thing I learned in this little course of discovery that I underwent is that we've actually already had a dry run for a convention for proposing amendments. We've already done it once. In 1861, when it looked like the country was going to be riven by civil war, when several southern states had already seceded, the great Commonwealth of Virginia, anyone here from Virginia? Yeah. The great Commonwealth of Virginia called a convention for Washington, D.C. And the purpose of this convention was to propose a constitutional amendment or amendments to stave off civil war. Now, this was not an Article 5 convention because it was not called as a result of applications by the states, but it was essentially the equivalent. It was a dry run for it. The chairman of the convention who was selected was former President of the United States, John Tyler. The vast majority of states that had not yet seceded met in Washington. They drafted an amendment. They voted according to the protocol of one state, one vote. They followed all the protocols that the founders anticipated for the convention for proposing amendments. And they came up with a constitutional amendment which, if adopted, might very well have staved off the Civil War, saved 600,000 American lives, and, by the way, because of the way the amendment was drafted, put slavery on the route to extinction. Unfortunately, because this convention could not present directly to the states, it offered the amendment to Congress, which did nothing. Congress did nothing while the country was being torn apart, just as Congress is doing nothing to deal with the overreaching federal government today. Now, let me just finish up here by making a few points regarding the runaway scenario. The claim that if we ever had a convention like this, it could be a constitutional convention which could do anything it wants, careen out of control, take over the country, presumably come and kill all of your puppies, whatever. There are far, far more controls over this convention than there are over the runaway Congress. For example, when the states offer 34 applications on any one particular subject, the convention is limited to the scope of those applications. Secondly, when Congress exercises its mandatory duty to call the convention after having received 34 applications on one subject, it follows those applications and specifies the scope of the convention. The convention may not go beyond that. Each convention committee, each state delegation, is chosen by the state legislature in such manner as the state legislature shall direct. That means that each member of the convention is recallable by the state legislatures, a well-recognized prerogative of the states meeting in convention. They are also under instructions from the state legislature. This is a convention for the purpose of Amendment X. It's not for the convention of purpose of Amendment Y. You start talking about Amendment Y, we're going to call you home. If by some miraculous event the convention were to come up with an amendment not authorized, then Congress would have the right, in fact the duty, to refuse to specify a mode of ratification. And since Congress is an institutional rival of the convention, it'll have every motive to try to rein in the convention if the convention acts in any way which is impermissible. And then there is the requirement that not 1, not 4, not 14, but 38 states ratify any amendment proposed by the convention. Could the convention change the method of ratification? No, because as I've already said, the United States Supreme Court says that the convention is empowered by the Constitution and subject to its rules. And if all of that wasn't enough, I would like to remind you that there are other possibilities of lawsuits all along the line. Anything that the convention does that is even arguably legal can and will be challenged in the courts. And contrary to what you may have heard, the courts have been willing to accept Article 5 disputes, and there is a long line of court decisions that shed light on Article 5. So the real risks are not from the runaway convention. The real risks are that we won't have a convention. The state legislatures may not act, and the federal government may continue to careen out of control. The convention may deadlock, like, for example, the Yorktown Convention of 1777 did when they had a tie vote among the states. The convention may not act, and the United States Congress may continue to careen out of control. The convention may propose, but then the states refuse to ratify, and Congress continue out of control. Or liberal groups might very well sue to try to throw a monkey wrench into the convention, and with the same results. But we do have the obligation to act. Let me just suggest to you one possible vignette in closing here. Let's suppose that, contrary to all expectations, the door were to open from the back, and in strode James Madison and John Dickinson. And after we all gasped and wondered how they got there, we all mobbed around them to talk to them. And several of us started complaining to them about what the federal government had become. That had become a government that had snapped its powers, its scope of its powers a long time ago. That had become a government that had burdened us with incredible debt. That had become a government that often was oppressive and couldn't even balance its own budget. And when we outlined all those problems to Mr. Dickinson and Mr. Madison, what would be their response? Their response would be, well, have you used the procedure in Article 5 that we wrote into the Constitution for exactly that eventuality? And when we sheepishly admitted that, no, we hadn't, we'd allowed ourselves to be distracted by alarmists and quacks, and we'd never really done it. No doubt they would look at us and say that the situation was our own fault. And they would be right.